Good morning, Mr. Elliott.
Good morning. Ladies and gentlemen, I apologise for the slight delay. Some bundles had to go all the way via the other entrance. Just to recap where we were yesterday, we were working our way through our skeleton argument. We'd gone through the basic principles and we were on to the refinements, as it were, and we'd done the first 5, just set out in paragraph 35 of our skeleton argument. We're now on to the 6th and 7th points, which are some smaller, potentially less important. So 6th point relates to the principle that the conforming construction must not go against the grain, which we know already. The refinement to that point is that a conforming interpretation is not barred merely because it breaches a prohibition in the national legislation. And the authority for that is Prudential High Court at 105, which we're going to see later. And we will also see, when we go through the illustrations, that where a court has options, choices before it, it may resolve those choices by selecting the conforming interpretation which is most in accordance with the grain, the scheme of the legislation. I'm just putting a pin in that, we will see that. And the 7th point will also take short, which is when a provision of domestic law is subject to a conforming interpretation, other provisions of domestic law continue to operate alongside the conformingly interpreted provision. And the reference for that is Prudential in the Court of Appeal, which is page 1601.
Could you just remind me which tab that is?
Yes, that is tab 56. Page 1601. I'm not going to go into the detail of this particular issue. Suffice to say that at paragraph 107, there is a recitation of the decision of Mr. Justice Henderson in Prudential, which that he was reading in a credit to section 231. And then at paragraph 109, Mr. Hewitt for the Revenue is saying, well, maybe we should do some tinkering with other provisions. No, says the judge. We do not agree. Once the conforming interpretation of section 2311 given by this court and FOI Court of Appeal and by the judge's declaration is applied, the other ACT provisions simply apply in accordance with their ordinary meaning, precisely as Prudential submits on the present appeal. And then at paragraph 111, the court has chosen to apply the conforming instruction to a specific provision, section 231, and the final 5 lines. That interpretation was sufficient to give effect in domestic law to the taxpayer's rights under Article 63, precisely because section 238 and section 241 continue to operate alongside section 231 as so interpreted in the usual way. So those are our refinements to the basic principles set out in Vodafone Prudential. Before moving on to illustrations, I wanted to conclude this section with some general points, considering all those points together and the concept of choices. In essentially every case where a court is considering a conforming construction, there will, at least superficially, be choices or options of exactly what the conforming construction should be and where it should be applied. HMRC submits that in many cases, what may appear to be choices are in fact resolved once we apply the principles that we've just gone through. So, for example, we've looked already briefly at Prudential High Court and we're going to look at it again. There are 2 options before the court as to how to remedy the UK legislation. We saw the taxpayer said they should be exempt, the Revenue said no, you only get a credit. Mr. Justice Henderson resolves that choice, inverted commas, by applying one of the principles, which was conforming interpretation should go no further than necessary to remedy the breach. Another way to resolve choices is not only if you've got two choices which are both in accordance with the grain, they both pass that test, consider which conforming construction fits best with the grain of the legislation or the legislative scheme as a whole, and once again we will see that illustrated shortly. So HMRC submit that in many cases, including this one, while there may appear to be choices, our primary argument is going to be that actually all of the choices are resolved by the application of those principles. That is going to be our primary case. Our secondary case, of course, will be thinking back to Vodafone. If you end up in a situation where you still do have choices, that's not a problem, as long as they are not of an impermissible nature. And then our third point, of course, is going to be, and in any event, it's not an impermissible choice if you are simply implementing what the Court of Justice has said is compliant. So there's three answers to any suggestion of choices. So now
the third doesn't really add much, does it? Because if the Court of Justice has only given one solution, then there's not really a choice at all, because the minimum interference principle deals with that. If the Court of Justice has said there are two or more ways of dealing with this, then there is a choice, but it's not resolved by the fact that the Court of Justice has said this is a solution, because it said there's more than one solution.
It's resolved by another principle, which would be don't go any further than necessary. I agree there's overlap, and in fact...
I'm not sure it's even just overlap, it's just that if you get to the third, then there isn't a tiebreaker. Because your third proposition was that if the Court of Justice has spoken, then you simply give effect to that. But if it's spoken in two different ways, then that itself can't be a way of resolving the tie.
It may more be to do with the character of how the CJ used. So, for example, in this case, we say the court has spoken and said that deferral is the right answer. So that is now where the case law has got to. And therefore, if the domestic court reads in a deferral, then it is simply implementing the character of what the Court of Justice has said. Now, then you may have a question over how long there are different ways to do it. Then you might need to plug in another principle, or maybe more than one principle, to get to resolve any option for the left. But it may be a case of actually some, in a particular case, both principles lead to the same place, and if there was a problem, then you're not resolved it. In this case, we say they both of those in parallel would resolve any alleged choice before you. So those are the general principles. We're now going to move on to part 2 of my submissions, which is cases illustrating those principles. And they're the 3 examples which, for your reference, are set out in our Panayi skeleton argument of 33 to 35. And the 3 are going to be Vodafone, FII, and then Prudential, plus a bit of FII. Before starting, some observations on these cases. First, in response to Justice Lang's request on the first day of this hearing, they are all cases about treaty freedoms. Second, they all involve retrospective conforming constructions, i.e. long after the tax years in question have gone. Third, they were each determined after intensely fought litigation, in which HMRC first denied that there was a breach at all. Then there are a reference, or an FII more than one reference, to the Court of Justice. So there is considerable uncertainty throughout as to precisely what the ultimate answer would be. You'll see that picked up later in the post-prudential as well, in particular. Fourth, they are cases where Parliament had legislated in a different way to remove the breaches. They mentioned in FII, Parliament applied an exemption. In Vodafone, Parliament introduced section 751A. So it's driving at the same thing, but is different. You might say it had all the bells and whistles that the appellants try to rely on in this case. It's different in that sense. Fifth, these cases are about actual tax charges, i.e. how much you actually have to pay, or how much you get back. Not merely when you have to pay. And yet in each case, when the conforming interpretation is applied, which you might say, you sort of follow the appellant's logic, is to the detriment of the taxpayer in the sense that you've got legislation and the taxpayer is always saying disapply. So if you can apply a conforming construction, that usually helps the revenue. And that isn't really the right way, but let's just follow their logic as it were. They're all comparable to our case. Actually, the correct approach is to say the legislation says one thing, you're getting something better, taxpayer. They're all analogous in that sense. But all these cases had a more severe impact on the taxpayer because it actually requires them to pay or get less back, rather than simply, here's an amount of money, when do you have to pay it? Which is what our case is. So first, Vodafone, which is tab 47. We've already looked at the principles, now we're going to take a slightly more detailed look at how it was decided. It's tab 47. We're going to start on page 975. So just in summary, the issue in that case is whether the UK CFC legislation could be interpreted in a manner which did not unlawfully restrict the taxpayer's freedom of establishment. And if we turn to paragraphs 1 and 2 on page 978, the proceedings arose because HMRC was seeking to apply this legislation, CFC legislation, and impose tax on Vodafone 2, which is referred to as V2, in respect of the income arising in its Luxembourg subsidiary, Vodafone Investments Luxembourg, or VIL, VIL. HMRC issued an information notice. V2 resisted, saying any imposition of tax under the CFC legislation would be an unlawful restriction on its freedom of establishments. So similar to this case, UK legislation applies a charge to tax. Taxpayer declines to pay the tax charge because they say it's incompatible with their directly effective EU law right. Happens to be freedom of establishment, same as in this case. No one knows at the time, one, whether there's a breach of EU law, two, what EU law requires, or three, what the effect of the UK legislation would be after EU law applies. In particular, whether a conforming construction would be applied or disapplication. And in Vodafone, there is a bit at the end, which my old friend, I think Mr. Fells, if we have time, is going to take you to, where they talk about disapplication, and it's discussed over because of course they do in conforming interpretation. But that uncertainty is not going to prevent a conforming interpretation being applied by the Court of Appeal. Paragraph 6 to 7 are the basic charging provisions by reference to controlled companies resident outside the UK, which are subject to lower tax. Paragraph 10, paragraph 8 first, refers to the 5 exceptions in 7481. And then paragraph 10 refers to a further exception in 7483, which is the purpose test. You've already heard where the grain is. The grain is very much there are exceptions. It's 5 in 7481 in particular. If we turn then please to 984. Paragraph 20, 3. So what the ECJ held in Cadbury-Schweppes was that the inclusion in the tax base of profits made by the controlled foreign companies in another member state was precluded unless such inclusion relates only to wholly artificial arrangements intended to escape the national tax normally payable. So on their face, the exceptions in the legislation, particularly in 748, did not limit the charge to wholly artificial arrangements. The question was, could that effectively be read in so that the legislation only applied to wholly artificial arrangements? Paragraph 27, HMRC argued that either on a conforming construction or on a disapplication means that the tax inquiry should continue. The taxpayer is saying there can be no conforming construction and disapplication in the tax inquiry because there can't be any tax charge. The side bit I don't really want to get into is that this case was actually an appeal against an information notice. All the same principles apply because the argument was, can there be a tax charge at all? Page 989, paragraph 39, is HMRC's submission. And HMRC's submission was the grain of the legislation is cast wide, sort of general rule, and then it's narrowed with exceptions. HMRC say that all that's required is for an additional exception to be read in, to be introduced, where the CFC is, in that accounting period, actually established in another member state of the EEA and carries on a genuine economic activity there. And that could be done, it said, either by adding a further lettered paragraph to the list in 7481, or you could add into 7483. So HMRC are essentially saying this is all very straightforward. You know what the problem is. You know what the solution is. The legislation already provides for some exceptions to the general rule. All we need to do is insert an additional exception to the legislation, which is in accordance with the grain. And we've already looked at paragraph 40, which are the 3 objections raised by the taxpayer. We haven't seen how the court dealt with all of those objections. Paragraph 44 is dealing with the first objection, which is whether it was in accordance with the grain of the legislation. So to my mind, the extension, this is Sir Andrew Morritt, to my mind, the extension of the exceptions to the CFC legislation for which counsel for HMRC contend is as permissible as either of those found favouring Guidon or IDT, does not alter the impact on other CFCs which are not accepted. Certainly it provides an additional exception, but as counsel for HMRC submitted, the grain or thrust of the legislation recognises that the wide net cast by 7473 is intended to be narrowed by section 748. Further, the terms of various exceptions were not intended to either be mutually exclusive or immutable. For my part, I would reject this objection of the conforming interpretation put forward by HMRC for counsel for HMRC. So in terms of the grain, the court accepts HMRC's submission as a general rule, which is subject to exceptions. Adding one more exception is not contrary to the grain.
Sorry to interrupt, Mr. Elliott. Is the reference to Schedule 25 to some power to amend the statute by the means of subordinate legislation? I'm just curious about it, but don't worry if you don't.
I will, well, we'll find that out.
All right, that's very helpful, thank you.
It looks like that, but we will find out.
Yeah, that was what I was inferring. Thank you.
The second objection, set out at paragraph 45, was that the conforming construction would essentially create 2 regimes based on whether the subsidiaries were based in the EEA or somewhere else. And the answer to that is, well, that's always the effect of the conforming construction. Because for a person who cannot rely on their EU law rights, they do not get the benefit, they just get the normal legislation. For a person who relies on EU law rights, they get the benefits. And that's worth keeping in mind. If you have one taxpayer whose rights are infringed and one who isn't, you apply the conforming construction to the first taxpayer and not the second. Equally, if you had a single taxpayer who had done 2 transactions, one of which engaged EU law and one didn't, you would apply the conforming construction to the first and not to the second. The point is that conforming interpretation only applies where there is a charge or other element which would breach EU law. And let's lay that down to bear in mind when we get on to thinking about interest in this case. And the court rejects that point at 54. It will leave it unaffected to other companies. And then paragraph 56 onwards is a third objection based on retrospectivity and impermissible choices. We've already looked at that. In fact, we've read the whole judgment when we were looking at the principles. So in Vodafone, the legislation applied a general charge which was subject to exceptions. The Court of Justice identified a problem, but also essentially also identified a solution by explaining precisely why the legislation was restrictive, which in that case was because it applied to arrangements that were not wholly artificial. And the Court of Appeal applied that solution by inserting an additional exception, which directly reflected the Court of Justice's ruling. And at the outset of the litigation, no one was sure what the Court of Justice would say, or what the domestic court might do, what remedy they might get, in particular in terms of conforming construction. That is simply a feature of conforming interpretation. That's the third objection dealt with in Vodafone we looked at yesterday. And to foreshadow the submissions I will make in part 3, HMRC submit that Vodafone is analogous to the present case in that the structure of the legislation is to provide for a general rule for payment with exceptions, in particular exceptions that apply for unrealised gains. And like in Vodafone, this court is being asked to add in a new exception which implements the CJU's precise solution to the potential breaches, applying the ordinary principles of conforming construction. Just for completeness, 996 Lord Justice Longmore's decision, judgment, which not entirely clear whether it's majority, but even so, there's nothing problematic or surprising in it. As he refers to section 2 and then refers to section 3 of the Human Rights Act, and then explains why, in this case, what the Court of Appeal is implementing is not a scheme, that sort of pejorative term. In human rights context, it's been said the boundary between interpretation and legislation would have been crossed if its purpose is the statute in which departs substantially from a fundamental feature of the Act. Res, which we're going to look at. If the proposed meaning would remove the core and essence or the pith and substance or something inconsistent with a cardinal feature. Nor can the process create a wholly different scheme from any scheme provided for by the Acts. We'll look at Lord Rogers' time. In the present case, the words which HMRC suggests should be inserted do not create a new and different scheme, nor do they offend any of the Act's cardinal principles, still less do they remove the core and essence of the Acts. Mr. Glick, QC for BT, submitting an exception for avoidance provisions in favour of CFCs which are not artificial would result in a different scheme from that envisaged in the Act, but I cannot agree. The proposed insertions merely adds a further exemption which is allied to, although different from the exemption granted to subsidiaries created or used without the motive of reducing the UK's tax. The Lord Justice Longmore is actually saying the same thing as Andrew Morritt. When he uses the word scheme, he's thinking, does this cut across a cardinal feature, go against the essence that if all the different wording you can use? Answer no, where you've got legislation with a number of exceptions, and you're being asked just to read one more in. And he notes it's of a similar nature. I'm not saying that has to be determinative, but if we needed to, we'd say the same here, in the sense that the exception we're asking for, the deferral for unrealised gains, is similar in nature the existing provisions. That's the first illustration, Redevco. Second illustration, FII, Court of Appeal 2010, tab 48. And it starts at page 998. If you're wondering why you have the approved judgment rather than the law report, it's because of a long procedural issue and the judgment being corrected, essentially, so that this is the official correct version, because none of the reported versions were corrected. It never reflected the amendments made to the judgment. So we're in tab 48, page 998 to start, and we're going to go to 1038. We're going to look at issue 6, but there's some background first under the heading issue 4. In summary, it's set out at 89. The UK system is that dividends paid by UK resident companies carried a tax credit for ACT, and that credit could be passed on to the shareholders of the parent company when a distribution was made. However, dividends paid by non-UK resident companies did not get any credit, so that when a UK company received a foreign source dividend, it would still have to pay ACT. That was the discrimination. In paragraph 89, you'll see the basis for issues 4 to 10 is that the ECJ had ruled the absence of a deduction, i.e. a credit, was a breach, potential breach. We then go to page 1041. It's under issue 6. To what extent can the ACT provisions be interpreted to be compatible with community law? We've reworded this issue to make it clear the question is about conforming interpretation, that is, whether the ACT provisions can be read in a manner which is compatible with community law as declared by the ECJ. It is well established the court must interpret a statute which on the face of it is inconsistent so far as possible to be compatible. This enables the court to read in words or limit provisions, provided it can be done by the process of interpretation properly called and does not go against the grain or cardinal features. References to cases that we see. Paragraph 98 states, attention has centred on section 231. The question is whether that section can be read in conformity, so that the entitlement to tax credit is available not just in respect of domestic source income representing distributions from resident companies, but also in respect of foreign source income representing distributions from other companies where community law requires them to be treated the same way. And section 231 is set out in paragraph 99. And there's no discussion, but we might note that given the problem is in 231, it's unsurprising that the court decides that the solution should be in 231. But there's no specific discussion in this decision. We've seen it in other decisions. And the Court of Appeal accepts that an interpretation can be applied. We turn please to paragraph 107. And may I ask the court please to read paragraphs 107 and 108 of the judgment. So this case illustrates the breadth of potential conforming construction, because the interpretation applied is actually quite general. It was that a credit would be available on distributions to the extent that community law requires a tax credit to be given in respect of that income too. What the court has done is it's taken a provision that specifically states that credits are only available for UK resident companies. That is, if you were to go back to section 231, it's companies resident in the UK. And it's extended that provision to non-UK companies where EU law requires. And it shows that the interpretation can be formulated simply by reference to the requirements of EU law, no more precise formulations needed. And for reference, the Supreme Court ultimately refused permission to appeal against that ruling, so the issue does not go any further. That's the second illustration.
This is to do with free movement of capital. Is that the relevant part of the...
It depends if we're looking at portfolio or non-portfolio.
I'm just trying to see what the infringement of the...
Could be, I think it's both, actually, or potentially both. If we go back to page 1038...
If you look at the index on page 999, it sort of sets out the issues that the court considered, and from a quick look, it looks as though the issue was compatibility with Articles 43 and 56.
Yes, so which is both. So one of the reasons you have a distinction between portfolio and non-portfolio is if you have control, then that engages freedom of establishment. If you don't, then that's freedom of capital. That's just a general principle of how you distinguish between the two freedoms. That's one of the reasons. In this case, you're looking at freedom of establishment, it's about control.
Right.
So it looks like that discussion is actually both.
And presumably one of the reasons that the court framed its interpretation in this way is so that if the distributions were made by companies that were not based in an EU member state, the normal proportion would still apply.
Is this about the formulation that you need?
Yes,
where you look?
well, in 107.
Well, look, for what it's worth, a personal view. You only have the conforming construction if you've got a prima facie breach.
Exactly.
So, although it's often read in when you work out what it needs to say, you don't actually need it because no company that doesn't have its EU law rights engaged can actually would ever use that application anyway.
Sorry, I didn't ask a very clear question, but I mean that seems to be what it's getting at.
Yes, but often the convenience, and the Upper Tribunal did it in this case, you read in where there's a breach of EU law, where there would be a breach of EU law.
Yeah.
It's not strictly required, actually. Third illustration, a bit more involved, is going to be prudential, followed by how that's interpreted in FII. That's tab 53.
Sorry, tab 53?
53, yes, is where the starts in, which is 2000, prudential 2013. And it's the conforming interpretation of the UK tax charge, Schedule D, Case 5. Parts of this judgment we're going to look at are upheld by the Court of Appeal and then the Supreme Court in 2018. Start please with paragraph 9 on page 1324. So we're looking, that starts to list the issues, we're looking at issue 1. How the invalidity of the Case 5 charge might be remedied. The problem arose in the following way. Paragraph 20. Section 208 of ICTA excluded dividends received from a UK resident company from the charged corporation tax. Paragraph 21, that foreign source dividends are charged a corporation tax under Case 5 of Schedule D. Double tax relief is given for withholding tax, but not for the underlying corporation tax on the profits of that overseas company, i.e. the profits from which the dividends are paid. That's the difference in treatment. And that comes in from, if we turn please to 1347, it's section 790, which is set out at the bottom of the page. And it's a bit of a convoluted provision, but the discrimination comes from subsections 4, 5 and 6. And the judge then summarises it at paragraph 83 at the end. The credit for withholding tax, where it was not provided under the tax rate, is provided by 79.4 5C1 but a credit for underlying tax through falling through the general requirements is excluded by 5C2, 6 and 6A. If you look above, subsection 4, which is the credit, shall have effect subject to the following modifications. And under C, the credit shall not be allowed for overseas tax on dividends paid by a company resident in the territory unless you fall within 6. And 6 says at A you have to have not less than 10%. So if you are a portfolio dividend situation, a less than 10% holding, Parliament has provided an express prohibition on you getting a credit for the underlying tax. And yet, the court is going to read in a credit directly contrary to that prohibition. Paragraph 84, the reasoned order of the ECJ had established that the case 5 charge on portfolio dividends infringed EU law. That was because of the lack of a credit. And that's stated at paragraph 89 on page 1350. First, the ECJ has already ruled definitively in the reasoned order on the invalidity of the case 5 charge in relation to portfolio dividends, which are an issue. This ruling identifies the vitiating feature of the UK legislation as its failure to afford a credit for the underlying tax and gives no hint of the existence of a second failure connected with the nominal rate of tax. So, there were two rulings. There was the first ruling, which didn't refer, but then, as you've seen in the second sentence, there's a reference to a second failure. There was a reasoned order from the ECJ in what is sometimes called FI ECJ2, and the claimant said that gave rise to a second failure. If you are interested in what that was in those proceedings, it's actually set out back in 65 to 72. But as a summary, what was said was there was a lack of equivalent treatment because whilst the UK applied the same nominal rate of tax to resident companies which paid and received dividends, the effective tax rate paid by the dividend-paying company was usually lower than the nominal rate, and that is because they might have, for example, expenses which offset their profits. So that's the restriction. And in fact, if we go, please, back to paragraph 73 on page 1344, which is discussing the ECJ's judgment on justification. In summary, the defence of justification failed because proportionality was not satisfied. And in particular, it's the quotation of paragraph 62 of the judgment you see on the next page. For the purpose of ensuring the cohesion of the tax system, national laws which took account in particular, also under the imputation method, of the nominal tax rate to which the profits underlying the dividends paid have been subject, would be appropriate for preventing economic double taxation, for ensuring the internal cohesion, being less prejudicial to the freedoms. So there was a justification in principle, but there would have been a less prejudicial way of achieving the justification, which was to take into account the foreign nominal rate, or FNR. So that's what EU law, that's what the court has told the national court. And Mr. Justice Henderson at paragraph 76, the next page, sideline passage, concludes that therefore the Court of Justice would in principle accept a dual system combining exemption for national dividends with the grant of a tax credit at the foreign nominal rate. That's a combination of the judgments. He said, right, we're going to need a dual credit, something which has no existence at the point in UK law. He's identified the solution. Question, can that be read in when there is no such regime for dual credit? In fact, there is an express prohibition on portfolio dividends getting any credit at all. We turn now back to paragraph 85. So this is now, can we do a conforming interpretation? 85. In order to answer this question, it's first necessary to understand in precisely what relevant respects the UK legislation infringed Article 63. The inquiry was both a negative and a positive. Negatively, what's the defect? Positively, what would have been required to eliminate them? And then he goes through and identifies what the negative side is and what the positive side is. And that is the approach HMRC adopted in this case, in which the tribunals below adopted. What's the problem? What's the solution? And then there's a discussion about what the precise defect is, and a rejection at 86 to 92 of HMRC's submission that there's only one problem. Paragraph 96, the reaffirmation of his conclusion. What EULAW requires in order for EULAW to apply is a dual credit, or a credit for the nominal rate of tax in addition for the credit of the actual tax. And then paragraph 100, the court turns to decide whether that result can be achieved or whether the case 5 charge must just be disapplied. As usual, the taxpayers are always saying we're just a disapply charge. And the judge sets out the principles at 101 and 102 that we looked at yesterday. 103. Applying these principles, I consider it falls well within the scope of conforming interpretation to construe section 790 as providing for the grant of a tax credit as foreign dividends to the extent necessary to secure compliance with EU law. Since section 790 already provides for the grant of a tax credits in the case of both portfolio and non-portfolio dividends, the grant of a further tax credit for portfolio dividends will not go against the grain of the UK tax legislation, nor would it provide the court to make policy choices for which is not agreed, because the sole purpose of the tax credit would be to secure compliance with the judgments of the ECJ. There's 3 points there. First, the construction is not against the grain, because the construction is, you already have a number of credits, we're just adding another one. That's quite similar to Vodafone. We've got a number of exceptions, we're adding another one. Similar to this case, we say where the legislation provides for different dates for payment and deferrals, and the Upper Tribunal just read in another one. Second point from that paragraph, the High Court is not being asked to make policy decisions for which it's not equipped, because it's implementing judgment of the ECJ, same as in Vodafone. Third point, as we've already seen, the legislation contained an express prohibition on a credit of the type Mr. Justice Henson was reading in. Does that go against the grain? No. Please read paragraph 105 of the judgment. That is the paragraph which I referred to for our 6th refinement, which is the proposition that a conforming interpretation is not against the grain merely because it breaches a prohibition of legislation. Just whilst we're here to save Mr. Fell time later, might I ask you to read 106 as well, which is about the interaction between conforming interpretation and disapplication. That anticipates the point Mr. Feldman discussed when we get to disapplication, which is disapplication is not treating the offending provision void, it's treated as without prejudice to directly enforceable rights. So that, turning back to conforming interpretation, what Mr. Justice Henson did in Prudential was take the existing machinery, expressly denying a credit for the underlying tax, and which did not say anything about foreign nominal rate and the court held that it could apply credit of the higher of the underlying tax and the foreign nominal rate capped at the UK rate. And that was permissible in the context of legislation that gave some credits, albeit there needed to be a credit of a novel type. And by doing that, he was directly addressing the offensive feature of the domestic legislation. That is not quite the end of this illustration. Because in Prudential, there was no dispute about what the foreign nominal rate was. That was an issue picked up in one of the FII decisions. And that is tab 59. And that was in relation to non-portfolio dividends. And I'm showing you this because it is an illustration of how to identify an appropriate conforming construction and the types of choices, inverted commas, that are permissible. So this is the 2016 FII Court of Appeal judgment. We're on page 1693.
So sorry, which tab is that?
So that's tab 59.
Thank you.
Just going back to the last case, the Prudential one, that went to the Court of Appeal, is that right?
Yes, it did.
I think it's not this. It's not this.
No, this is picked up in a different stream of the litigation.
And was anything that was said by Mr. Justice Henderson in that case doubted by the, or affected by anything in the Court of Appeal?
No. I think when I introduced it. Yes, upheld by the Court of Appeal and ultimately by the Supreme Court in 2018. And we're now going to look at another bit of his reasoning, which is endorsed by the Court of Appeal, but a different bit. So we're under the heading Issue 2, what is the appropriate foreign nominal rate? Paragraph 90. 3 options are identified. I don't think we need to go through them in too much detail, simply to understand there were 3 different ways of rendering the legislation compliant, i.e. 3 choices. Paragraph 91, Prudential, that's reference to portfolio dividends, High Court 1, had adopted the first approach, but there were different considerations when you came to FII. Paragraph 92, there is no clear guidance from the Court of Justice. So, Mr. Justice Henderson in FII and the Court of Appeal has identified this is going to be a case where we can't rely on the principle of implementing what the Court of Justice has told us. We don't have a precise answer to what are these 3 options. We're going to have to fall back on the domestic principles. Paragraphs 93 to 96 is the judge's solution, i.e. rejecting the first option and preferring option B. And then 96 is the reasoning. And this is an endorsement of what Mr. Justice Henderson said. The problem of how to treat mixer companies, the analogous arrangements to my mind is more difficult, and the choice between solutions B and C reflects a fundamental difference of approach between the 2 sides. In essence, the claimant's approach is to take the UK system as it actually was and make only such modifications which are appropriate to accommodate the ECJ's ruling. The revenues approach by Congress is to start from first principles and try and work out how far UK law could lawfully have imposed a Case 5 charge on the various streams of income. And the judge prefers the claimant's approach to take the UK system as it actually was and to make only such modifications are as appropriate to accommodate the Court of Justice's ruling. And that approach is upheld by the Court of Appeal, in particular at paragraph 113. There's an endorsement of Mr. Justice Henderson's way of getting there. As to the difference in approach, which is reflected in the example I've discussed, I consider the claimant's approach as set out in their alternative cases to be preferred, the question of the unlawfulness of Case 5 charge does not arise in a legislative vacuum. It has to be considered in the context of the actual tax system operated by the UK, which was binding as a matter of domestic law and has to be applied by the English court, subject only to disapplication or conforming construction. The introduction of a credit for tax at the FNR should therefore be implemented in a way which, as far as reasonably possible, reflects and goes with the grain of the existing UK legislative scheme. It seems to me that the claimant's approach respects this principle more closely than the revenues, because it adapts and builds on the existing machinery for giving credit for underlying tax. So the endorsed approach was to take the context of the actual UK legislation and introduce the credit for tax in a way which, as far as reasonably possible, reflected and went with the grain of the existing UK legislative scheme. And that's not saying one of these options goes with the grain and one doesn't. It's saying they both can go with the grain, potentially. Which one is closer? And that we submit as an endorsement of Mr. Justice Henderson's approach of making choices, inverted commas, making decisions by reference to which option more closely respects, goes with the grain. That is using the legal analysis and the principles to resolve a choice, even where you have no guidance from the Court of Justice on that particular specific point. If you do have guidance, then it's even easier. So just to summarise, that is the third illustration. Conforming interpretation was used to adapt the UK tax system to ensure it accorded with the European Court's decisions, despite the fact there was no mention of a credit at all for the foreign nominal rate in the actual UK legislation, and for portfolio dividends, there was a prohibition on the credit. And it illustrates the resolution, in the loose sense of the choices before, in particular, Mr. Justice Henderson, which is endorsed. There were different ways the legislation could have been made to conform. Just as in this case, the exercise of identifying the appropriate interpretation is driven by the requirements of EU law and identifying what fits best with the existing legislation. So yes, there were choices, but they were not of an impermissible nature. And that reflects Vodafone paragraph 59, where it is said in express terms, the existence of choices is not an objection to a conforming interpretation. That is not to say that there are certain categories of choice which are impermissible, and we're going to turn a little bit later to see those types of categories, Ries, Anderson, those types. In this type of context, notwithstanding the complexity of what the court was being asked to do, they did not consider those were impermissible choices. We'll deal with that when I get to response. We're now going to move to part 3 of my submission, which is the conforming construction in the present case. This is our positive case. And it's developing the submissions for your reference. It's Redevco skeleton 37 to 40 in our Redevco skeleton, and in our Panayi skeleton it's 36 to 42. HMRC submit the Upper Tribunal was correct to conclude that it is permissible to apply a conforming instruction to sections 59B and D, so as to read in an option to defer payment of exit tax in 5 equal annual instalments. That conforming construction is driven by the scope of the EU law right and does not require choices of an impermissible nature and is in accordance with the grain. It does not fall foul of any of the 3 recognised limitations on conforming construction. First question, why is the conforming construction in 59B and D, as Mr. Fell submitted, the provisions that impose the tax charge themselves do not breach EU law? We're talking about section 18 and section 185, as stated by the Court of Justice in Panayi, in particular paragraphs 52 and 56. It is permissible for a member state to charge tax on exit because it has been stated it is permissible to determine the amount of tax at the time of exit. And that is why the vice of the UK legislation does not lie in 185 or Section 80, because those are the provisions which determine the amount of tax due at the time of exit. Those provisions say nothing about when the resulting tax charge need be paid. The breach of EU law arises because of the provisions requiring immediate payment. 59B for Panayi, 59D for Redevco. So stage one of the analysis, conforming interpretation analysis, we know the problem and we know the offending provisions. As set out in FII, we looked at yesterday, that is likely to be the appropriate place or appropriate location for any potential solution. It doesn't actually matter. Appropriately worded, you could put this provision in any way you liked. But the most appropriate place would be in the actual provisions that cause the problem. And they could be a separate section or they could be a subsection within that. What is the solution? Once again, as Mr. Fell submitted, it is deferral. It has been established that deferral over 5 years is proportionate. I'll come on to other options, as it were, and that is crystal clear from DMC at 62 and from the AG in Panayi, paragraphs 55 and 58. And we say that's also been reflected in ATAD. ATAD, of course, which imposes an obligation to charge an exit charge in those particular circumstances for the department. It has not been established that anything less than 5 years would be compliant. Looking at the positive powers of conforming construction, reading in a deferral of payment over 5 years is evidently within the muscular doctrine of conforming construction. There is no requirement to identify precise wording, but in this case the Upper Tribunal had no difficulty in identifying the wording that would be necessary, which was where the taxpayer's right of freedom of establishment would be infringed. I put square brackets around that, fine. The taxpayer has an option to defer payment of the exit tax in 5 equal annual instalments, with the first instalment payable on the normal due date for payment. That's the wording used by the Upper Tribunal. The only issue is, are any of the restrictions or the limitations engaged? Does it go with the grain? Does it involve impermissible choices? The grain of the legislation we submit is that it creates a general rule for payment, which in summary is actually you pay about 9 months after for each type of taxpayer. Got one regime for trusts, one for companies. The general rule is 59B for individuals and trusts, and that's you pay by 31st of January in the following tax year after you end of your after 5th of April end. And for companies, it's 59D, which requires payment of corporation tax 9 months after the end of the period. It happens there are actually other provisions, so depending on what type of company, but that's the one that applies in this case. There are exceptions for particular charges arising on what might be called dry tax charges or unrealised gains. Mr. Fell took them to you yesterday. If we need to go back, please let me know. But the prime example of that is section 281, where the taxpayer makes a gift, i.e. a disposal for no consideration. Then the tax is payable in 10 equal yearly instalments. And then there's section 280, and that provision concerns deferred consideration. So the general position would be, if you make your disposal, it doesn't matter when you get your consideration, you are immediately chargeable. So what this provision does, if you agreed, I'm going to dispose now under a contract for £1 million, but we're going to agree that the consideration is deferred, I'm going to get my £1 million in 3 years' time, in principle you've got to pay the tax immediately. That's why 280 applies. it allows for payment by instalments over a period not exceeding 8 years. So Parliament has provided for exceptions to the general payment rule. And the nature of the exceptions are payment by instalments in the case of unrealised gains, dry tax charges, i.e. where they don't have the consideration with which they can pay the tax.
It's a bit different, isn't it? Because I say a bit different. It is different because in those cases the asset is no longer in the hands of the taxpayer. So the taxpayer, in the case of the gift, the taxpayer has given away the asset. There's a gain which it prima facie has to pay the tax, but it's given more time to pay it. The situation here is a different one because it's what in some cases is called a hidden gain, where the taxpayer still has the asset.
Yes, but in each case it's effectively a deemed gain, because if you give away your assets, so capital gains is charged by you buy it low, you sell it high, tax charged on the amount in between. Effectively, you will pay a proportion of that gain to HMRC.
I just wonder whether it's a deemed gain or whether it's just saying it is a chargeable event when you give it away.
Well, it's a deemed gain in the sense you haven't
got the money.
You haven't made a gain in any real
Well, you
sense.
haven't got the money in your
Yes.
hands.
You haven't got the money. That's
the asset has gone up in value by hypothesis.
Yes, because they're each of these. Well, if you give something away, that would automatically give rise to a market value charge under Section 18, even if obviously you don't have any money. Similarly, here the charge is on the market value of the assets when the trusts move. So they both actually charge market value, even though you have not got market value, you haven't got anything. I agree, obviously they are applying in slightly different situations, but there is a common theme, which is Parliament recognises that where you've got an unrealised gain, you don't have the money, you should be given the payment of the tax, not the assessment of the tax, the payment. But yes, of course they're different. They are different exceptions, but they're sufficiently similar, we would say, that we can see the overall grain of what Parliament is driving. And we certainly say that this case is analogous to Vodafone, which is to have the general rule of exceptions. And essentially what the two FTTs and the Upper Tribunal has done is to create a further exception for payment in annual instalments where EU law requires it. It could equally be said to be analogous to the regime in Prudential. That was the regime providing for various credits, and the High Court read in another one. Here we have the regime providing for different dates, and you're being asked to read in a new one. And for that reason, we say the legislation is in accordance with the grain of the legislation, i.e. to read in a further exception. So that grain isn't actually really one of the big objections to see before you. It's more to do with legal certainty and choices. Legislative choices. Now, in the responsive section of my submissions, I'm going to take you through some of the case law on where there have been impermissible choices. But I will set out, develop the 3 points I've already foreshadowed. First, we say there are in fact no relevant choices at all, because once you apply the principles, the result of the legal analysis is that there's really only one option before you. And the principles include, of course, going no further than necessary, addressing precisely the breach, applying an interpretation that fits best with the grain, allowing the rest of the legislation to apply as normal around. When you apply those principles, the ostensible choices are resolved. Should the deferral be 3 years, 5 years, or 10 years? The CGA has never said 3 years, so 5 years, 10 years, or 100 years, it could be anything. That choice is resolved by the principle of going no further than is necessary, i.e. giving the taxpayers no more than that to which they are entitled. when should the instalments be paid? Well, the other deferral provisions provide for payments in annual instalments, so it is closer to the grain to apply the same for the deferral. This deferral. Penalties. It's not a point that was raised below. We've got a point about penalties that was raised on Tuesday. Well, we looked at section 59C, Mr. Fell handed up. Actually, penalties just run from the date of 59B. So you apply the principle that the legislation continues to apply around it. Obviously, there's no suggestion that you should have a penalty if you've got a new law right to defer payment. And that's consistent also with the way that 280 and 281 would operate as well. Obviously, you wouldn't have a penalty if you were paying by instalments on an unrealised gain. So our first point is the application of the principles means there are in fact no relevant choices in this case. The second point, even if there were choices, we say they're not of an impermissible nature. We're going to look at some cases, but essentially we say there are cases where the court is required to make policy decisions with important practical repercussions which the court cannot evaluate, in particular those affecting third parties. But in this case, the consequences are entirely obvious, because all you're being asked to do is determine how long an individual taxpayer should have to pay their tax. There are no third parties, and the consequences are restricted to the date of payment. And on choices, compare the complexity of the choices facing Mr. Justice Henderson and the Court of Appeal in Prudential and FII about foreign nominal rate, the dual rate, and then which foreign nominal rate should be applied. The reason I bring that illustration to your attention, so the court can make far more complicated choices than those that are before you. i.e. where there are real options. That's not impermissible. Just to address one point, the appellants try to say that there are ramifications because the conforming construction will not apply just to these two taxpayers, it will apply to any other taxpayers whose EU law rights are engaged. There are all these taxpayers calling Mr. Johnston. It's news to HMRC because obviously HMRC has sight of all the cases, and there is just one other case, which is a Section 185 case, which was supposed to be heard last year but stayed behind this one. There were originally 4, if you include Gallagher. It's actually a bit different. Of course, the CJU actually decided it wasn't really an exit charge at all. There's 3 cases, but in a sense it wouldn't matter. It doesn't matter if there's 100 or 1,000 cases behind this one, because that's always the way conforming construction works. You've got a case like Vodafone or FII, the group litigation. The fact that your conforming interpretation will be applied not just to the taxpayer in front of you, but also to lots of follower cases, does not engage the wide ramification, because in each individual case, you look at each case, the only person affected is the individual taxpayer. There are no third parties, no ramifications of the type we'll see in Ries or Ofgen. And this isn't even about liability, it's just about time to pay. Third point on choices, appreciate I've already had some pushback on, is that HMRC submit there can be no impermissible choices where the court is implementing the jurisprudence of the CJU. We say the court has laid down a framework which provides that the solution in a case of this type is to have a power to, an ability to defer over at least 5 annual instalments. An implementation of that solution does not trespass on the forbidden ground of judicial legislation. That's Vodafone and Prudential. And that was also the analysis of the present case for your reference in Banks, which is tab 67. 7, it starts on 2031. So this was Mrs. Justice Fowler, as she then was, and Judge Harrington sitting in the Upper Tribunal, and it discusses the Panayi decision. So this is, it's only Upper Tribunal, it is comfort. And if we turn, please, to 2081, background to banks, by the way, is it was all about Section 24 of the Inheritance Tax Act and gifts to political parties. We don't need to know that background, and it was actually articles, it was human rights, articles 10, 11 or 14, and whether there could be a conforming construction in accordance with human rights. But actually, the Upper Tribunal decided there wasn't even a breach, so this bit on conforming construction is obvious. So they went on to consider, if there had been a breach, so assuming there was one, whether it would have been possible to undertake a conforming structure. And in the course of that, it considered the existing FTT decision in Panayi. And the discussion starts, it's actually at 2082, paragraph 230, sorry. Mr. Afzal for the taxpayer arguing that conforming construction did not go against the grain and relied on Panayi. And for your reference, the discussion runs all the way to 243, but the key paragraph is 237. The conforming interpretation that Judge Mosdale chose in that case, as set out of 166, was that the legislation in question should be read as involving an option to defer in 5 annual instalments without liability to interest. In doing so, Judge Mosdale adopted an interpretation which clearly recognised and built on the specific defects that the Court of Justice had identified in the legislation and reflected earlier case law indicating that setting the period at 5 years was proportionate, see 28 of Panayi. And then also 242, so the Upper Tribunal was actually distinguishing this case, but it's giving the summary of why that decision was made. We do not think that either Panayi or Gallagher assist us to any material extent. They do not establish any precedent to decide on their own particular facts. In any event, as we've mentioned, in Panayi, the FTT had the assistance of CJU case law, which set out a clear framework within which it could make its choice of a conforming construction. The position was similar to Vodafone 2, where at 59 the court said it could choose a conforming construction that faithfully followed the conclusions of CJU. And it says that's not the position in their particular in the bank's case. So the Upper Tribunal considered that common construction was permissible in Panayi, in this case, because it was applying the CJU jurisprudence. In fact, it describes the present case as one where there is a clear framework within which it could make its choice of conforming construction. So we say there are no impermissible choices in this case. Before, there are going to be some ancillary points. Before we get to them, I'd like to address you on Schedule 3ZA and 3ZB. In response to the Court of Justice's jurisprudence, and in fact, I think some infraction proceedings, Parliament decided to enact exit charge payment bans in Schedule 3ZA and 3ZB. And like standard run-of-the-mill tax legislation, the drafting is detailed and contains a number of provisions. Many of them are sort of for the avoidance of doubt. It ends up being quite long. So, okay, the client who actually drafted it isn't here today. He was here yesterday. But as the Upper Tribunal said, the Upper Tribunal in our case said at 149, what Parliament decides to do is a different process to the one being undertaken by a court on Section 2.4. Parliament can do what it likes. It is sovereign. It may choose to give, for example, taxpayers a more generous treatment than their EU law rights can give them. And in fact, that's essentially what Parliament did in FII. We've seen the debate, should there be an exemption, should there be a credit? Parliament ultimately said, well, Parliament had said already by the time of that case, exemption. It can also depart fundamentally from the grain of the pre-existing legislation. It can scrap the whole regime and write a new one. But the duty of this court is circumscribed by Section 2.4 and by the various limitations. But just because this court knows what Parliament did, just like the court in Vodafone knew what Parliament had done, it had enacted Section 7.51, which drives in the same direction but was different to the conforming interpretation the court actually implemented. And in FII, Parliament did something quite different as well. That is not directly relevant to the different exercise that this court is undertaking in Section 2.4. It's simply a different process with different considerations.
And made in the exercise of completely different powers / duties.
Yes. As I say, Parliament is sovereign, isn't bound by anything.
Yeah.
You have a framework, you've got an EU framework, and you've got a framework of principles on conforming construction that drive you to an answer of whether and what the conforming interpretation might be. Parliament doesn't have any of that. It is just a different constitutional process.
The similarity being, however, that Parliament is only making the amendments or creating the new provisions because it's seeking also to be within European law. And of course that is part of the purpose and the direction which the court is taking.
Yes,
That's the only...
You would hope they're aiming at the same, they are aiming at the same thing, which is compliance with EU law. So in this case, it was the companies after MGI that were infraction proceedings. That's what led to the corporation tax exit charge provisions. And this court is, in a sense, doing the same process, which is trying to render this legislation compliant. Because it's the how rather than the end, the objective.
One of the submissions that was made yesterday was that there are, as with any legislation, there's a date for it to come into force, and I think it was a 2012 date here, but that Parliament deliberately did not make the legislation retrospective, to go back, for example, to the relevant exit dates of these taxpayers. And that was supplemented by a reference to something that Lord Justice Lewis had said in the Appellant case. I don't know whether you want to...
Yes, I was going to come back and deal with it now. Well, preliminary point, from a question from the court came that would it then have been compliant if it had been retrospective? And the answer from my learned friends was no. Still wouldn't have been compliant. So we still would have been here, which sort of sells the pass that unfortunately retrospective legislation, they would still be saying is not compliant for exactly the same reasons. But the answer is, we say it's the answer given by the Upper Tribunal, which we'll come to later, which is it's quite standard that tax legislation comes in force usually from the date it's announced. We say that in the same way as in Vodafone or FII, the mere fact that none of that legislation was retrospective, that cannot be applied to the court undertaking its duty under its obligation under Section 2.4. There is reference in amply award, but we're going to that is one of the factors taken into account. It's an indication, certainly that it cannot be decisive. Otherwise, most of the cases we're looking at are wrongly decided. Amply award is the only occasion when that is taken into account. We are going to look at it later. It was far, there's a number of other points going on.
I mean, it might be said that it's one thing to say that Parliament has decided that its legislation shall only apply as from a certain date. It's quite another thing to say that Parliament has somehow thereby decided that there cannot be a conforming interpretation in respect of earlier times. That's a big leap.
That is, yes. The Parliament has implicitly ousted the court's obligation under Section 2(4).
If it could.
Well, indeed.
I suppose it would amount to a change to the 1972 Act.
Yes, it can.
It's very complicated.
Yes. Given and feared, I'm not going to stand here and say that it's never a factor to be taken into account. I'm not here to argue with Justice Lewison's approach, but we are going to get it later. But it's certainly not decisive, and we don't say it's even weighty. It's not a very weighty factor at all. It is entirely standard. Tax legislation is not introduced retrospectively. It's introduced only retrospective in the sense that often it's from the date of an announcement of exactly what the legislation is going to be. You don't have it. You do have retrospective legislation, particularly with all sorts of problems we're going to see in play. Yes, so we say that it's not decisive, it's not weighty. So it cannot oust the obligation of this court under 2(4). Two ancillary points on the conforming construction.
Please, would you keep your voice up, because you're competing with the refuse cart.
Two ancillary points on the conforming construction. The first is going to be whether payment should be accelerated by realisation, and the second is going to be interest. Acceleration. We know and we accept that in principle it would also be proportionate for the legislation to provide that payment be deferred for 5 years, but that payment is accelerated if the asset is realised within that period. That would be proportionate. That is what ATAD, DMC, it was provided for. So the question then becomes, I would say, of course in practice that's going to make no difference at all in this case, because they haven't paid and they've already had far more than their 5 years already. But in principle, should this court include an acceleration mechanism in your conforming construction? And HMRC's position on that is that whilst it would conform with EU law, and of course with the muscular doctrine, you shouldn't because of the application of two domestic principles. The first, we say, is to go no further than necessary, in the sense that once you have written in your 5-year deferral, you stop writing. Because at that point you have rendered the legislation compliant. You do not need to go any further and add on anything else. And that is what we'll see later. That's what the Upper Tribunal said was the answer. The second consideration we would add is about the grain. Whilst it would not be against the grain to read an acceleration, there aren't any provisions that do that in express terms. So once you've got your payment plan or your 10-year deferral under 280 and 281, there's nothing in there that says, well, if you get paid earlier or something, like you couldn't get paid earlier on a gift. But for example, your consideration gets paid earlier. So there's no provisions at the moment which provide for an early acceleration. So we say it's more in accordance with the grain, not to add that.
I mean, acceleration, if one's thinking about it as the balance between the parties, is a point in favour of the revenue, isn't it?
In the sense that payment is going to be earlier. It's the earlier of 5 years or payment.
Yeah.
That's what has been recognised as being compliant. You can have an acceleration.
It's not a more favourable thing to the tax.
No, we're not talking about realisation alone. It's only with the 5 years.
Yeah.
Realisation is also compatible, but as the Court of Justice itself has recognised, if you only have realisation as the limit, that's going to go further than necessary. My lord, you may remember in Gallagher, that was the argument being made. Now, they wanted realisation within the group because the tobacco brands were never going to be sold by the Gallagher group. In this case, they were sold very shortly after the migrations. So that goes too far. We would also make the point, of course, if you to a realisation, sort of go down one of the options that's being pushed forward and sort of try and calculate it then, well, you don't actually have an exit charge anymore. You've just got a normal tax charge on the disposal of an asset. It makes a bit of a mockery of the Court of Justice's consistent statements that exit charges are justified, and then ATAD saying, actually, in certain circumstances, you have to impose them. They are an important feature of the balance allocation of tax. So I'm talking about 5 years is the absolute maximum. Should you have an acceleration if the asset is realised earlier? Short answer, you could, but when you apply domestic principles, you don't have the, better answer is actually you shouldn't. You're resolving what might be seen to be a choice inverted commas there by the application of domestic principles. Interest. I'm going to deal with the procedural and jurisdictional issues of interest right at the end when I'm addressing the Redevco grounds of appeal. At this stage, I'm giving you what HMRC say is the answer if you wanted to say anything about interest. And we say that the Upper Tribunal was correct to observe obiter if it was, leave aside the fact of whether it should make an observation at all. If someone was going to give any guidance, it's correct to say that interest would still be payable from the ordinary payment debt. As Mr. Feller submitted, the Court of Justice has never said that interest cannot run from the normal date under national legislation. So when it comes to considering interest, it would be justified and proportionate for interest to be charged from the original date, which is the 31st of January following year of assessments, and for companies that's 9 months in the accounting period. That being the case, HMRC's primary case is that nothing needs to be said about interest, because when you're considering the charge of interest, there is no breach. Interest is a separate charge, a separate topic, albeit calculated by reference to the actual tax. The Court of Justice has accepted you can charge interest in accordance with the normal national provisions. So when you're looking at the actual substantive charge, you are doing the conforming instruction. Different topic, what about interest? Different charge, different amount. You don't have to do a conforming interpretation at all, because the interest charge is compliant with EU law. So that's the straightforward answer. The secondary position, if you thought that interest had to be accommodated some way and interact with your conforming construction, we say the Upper Tribunal is correct to say that the interest runs from the ordinary date because that goes no further than is necessary, gives the taxpayers no more than that to which they are entitled, and it also goes in accordance with the grain because section 280 and 281, also in relation to unrealised gains, you're allowed to defer, but the interest still remains chargeable from the original payment date. We say that's the grain of the legislation. So Parliament has said you can defer, but you still have to pay your interest.
Not saying anything about it might be considered somewhat unsatisfactory. I mean, I'm not prejudging the question of whether we should say anything about it, given the procedural background, which we're going to come on to. But in principle, not saying anything about it where you're doing a conforming interpretation might be considered rather unsatisfactory because it leaves it ambiguous.
Judge, you preempt, my lord, you preempt where I'm sort of going to end up very softly on interest. Of course it's up to this court. The interest in particular for Redevco, the calculations were back of an envelope as you've done this morning, not by me. I think we've all ascertained from the Redevco transcript that none of the maths should be left to me. It's about £2 million. Just across the 5-year deferral, that's what they're looking at. Not an insignificant sum. Being candid, it would be a shame if we had to have more proceedings just about interest and end up probably back in this court arguing exactly the same points, but with a slightly different focus. That's where I'm going to get to. You do not have to say anything. You are entitled to say something. Courts are always allowed to give guidance on points that are not immediately in front of them. It would be, we agree, and that's what the Upper Tribunal we submit had in mind, that it was trying to help the parties.
I'm not really, that's jumping ahead a little bit. I'm not suggesting, because we haven't heard argument on it yet, that we will say anything or think it's a good idea to say anything. I'm making a slightly bigger point, which is responding to your argument that you have a conforming interpretation which just says nothing about it, and then that, you say, leads to the conclusion that the national statute has already catered for interest, and therefore you say that essentially is an answer in your favour. And I'm just questioning that, because it seems to me that if the court is being asked to give a conforming interpretation, then in doing so, this is one of the issues that it might well think needs in some way to be addressed. We may end up saying, well, I'm sorry, it's too late, because the way this matter has been argued before the lower tribunals, and you're going to come on to that. But in principle, it seems rather unsatisfactory just to leave it hanging.
Well, I'm not suggesting to leave it hanging. I'm saying that if you were to consider it, so let's assume you're in that world, you are consciously not including any provision within your conforming construction, because when you look at interest, there's no breach. If you said absolutely nothing, then we're probably going to have a fight about that is the conclusion. We're saying, by saying nothing, by saying you do not need to do a conforming construction on interest, that is the answer in this case, because there is no breach in respect of interest. You might think, so that's our first position, but if you were going to go down that way, and if you were a court thinking to sort of try and help the parties, you'd probably have to put it in those terms rather than just say absolutely nothing. If you decide a secondary case, well, we've done a conforming construction and we've got to make interest interact. The reason I say that is wrong is because of the examples I gave earlier. That if you had a taxpayer, for example, with two transactions and one engages you and one doesn't, then the conforming interpretation of charges applies to the transaction where there is an engagement with you, and you just ignore it. You apply the normal legislation to the thing, the element, which doesn't engage you, where there's no breach. We say that applies to interest. But if you were going to go down the route and thought they had to interact in some way, then the correct way to read them together, we would say, would be to allow interest to run from the ordinary date. We say that is more in accordance with the grain of the legislation and goes no further than is necessary. If you decided the other way, then you thought, actually, no, it goes more, we're doing a conforming construction, we think it's more in accordance with interest actually when you run from the date, for a late instalment. So be it. So be it. It's a large amount of money, but in the grand scheme of this litigation, that is an option that's open to you, because you are being asked, we invite you to apply the principles and decide which one you think, make a decision whenever you have a sort of ostensible choice in front of you. We say by reference to the not going further than necessary in grain, the correct answer is interest runs from the original date.
So there was some suggestion that the FTT didn't have jurisdiction to deal with interest at all. Are you going to come
That's
on
the point I was going to come on. I can deal with all of this.
No, but if you're going to deal with it, because one point that's occurred to me is, if the FTT had no jurisdiction to deal with interest, then it might be thought that the Upper Tribunal only had jurisdiction to say that the FTT had no jurisdiction to deal with it.
Well.
But I'll just sort of leave you to think about that.
Well, I have, unfortunately, great length. The first, I'll give the short answer.
I mean, don't deal with it now if you'd rather deal with it.
Well, I will just leave this point here. The FTT's jurisdiction relates to amendments to close notices. That's substantial tax, nothing to do with interest.
Right.
What happened in this case was that we had the Panayi hearing, and at the end, Judge Mosdale not only decided to say something, some guidance on interest, she included it in her disposition section, as if she were making an order, some sort of binding order. And that was something that was not within her jurisdiction. In the same way as she couldn't issue an arrest warrant, she can't say anything about interest on a statutory appeal against a closure notice. All she can do is uphold or drop the amendments. So that was her jurisdiction.
Yeah.
But on appeal, the jurisdiction changes.
Right.
The jurisdiction is there an error of law in the first tier's decision, and then the upper tribunal, that's your jurisdiction. And the first tier tribunal in Panayi had dealt with interest. And what happened was the revenue actually appealed because it was in the disposition section. We couldn't just leave it there, be taken to accept it. So we did our own. There were two appeals from Panayi, one by the taxpayer and one by the revenue.
Yeah.
So interest was very much live in the Panayi appeal when the matter got before the upper tribunal. Redevco, now they may say, well, it had nothing to do with us, it wasn't mentioned by the FTT. As we saw yesterday, the FTT essentially accepted my primary submission, which is don't say anything about interest, it's not within your jurisdiction. But then they asked to be joined to Panayi, where it was live. And the jurisdiction of the upper tribunal, and now this court, of course, I mean, in one sense, your jurisdiction is defined by the grounds of appeal before you. And each taxpayer has raised a separate argument or ground of appeal about interest. So it's very difficult to see how you have no jurisdiction at all to decide interest in two senses. One, an argument put forward by each taxpayer is that you can't do a conforming interpretation because interest is a choice and it's impermissible. And I would find it difficult to see how you can't resolve that question, whether the existence of an option on interest stops the conforming interpretation, because that's directly relevant whether you can and can't. That doesn't mean you have to say what the answer is, but you may have to say respectfully sort of whether it's a block. The second point is what is the answer? What is the correct? How does interest work following the conforming interpretation? Now, what you say on that, given that ultimately this is still an appeal against amendments to a closure notice, will not be res judicata. It would be, if you said anything about what the answer, it would be obiter guidance by the upper tribunal.
Yeah.
But it's not outside your jurisdiction to say anything because three reasons. One, you have to decide that point about whether it stops a conforming construction. Two, it's a ground of appeal. It's one of the grounds you have to decide. Three, my submission, there is nothing that stops any court giving a view, an obiter view, on something, well, anything, but related to the matter in front of it. As long as it's sufficiently expressed, as the upper tribunal was very careful to do, in saying that this isn't before us, it's not something we have to deal with, but for what it's worth, this is what we think the answer is. I can't say that that's outside the jurisdiction of this court to give a view. It's also, for reference, not outside the jurisdiction, of course, for an upper tribunal court to raise an argument of its own motion.
I'm struggling a bit with the idea that if the FTT didn't have jurisdiction to deal with it, somehow the upper tribunal and this court do, just because it's been raised by the parties. If it's not within the jurisdiction of the FTT, it seems to me that the right answer of the upper tribunal and the Court of Appeal is to say it's not within the jurisdiction of the FTT full stop.
Well, in defence of the upper tribunal, though, it was faced with a decision of the first tier, which said we are making a decision on interest.
Yeah, and they could have said, well, that was not within the jurisdiction of the
and they did say that.
Full stop.
They could have said that, yes.
Yeah.
And that, I mean, it's quite clear what they were trying to do. They'd heard full arguments over the space of 2.5 days, as you have, and they say expressly, that for what it's worth, this is our view.
I mean, the other point that's made against you, as I understand it, is that in front of Judge Mosdale, the revenue was actually arguing for the very solution that she came up with.
In front of Judge Brooks, we were arguing for the... So Judge Mosdale...
I know, but I'm just dealing with Judge Mosdale for a moment.
I don't think that's right.
I thought that was the
I thought the
intention, that the...
I think the submission was that in the first year in Redevco, because we'd already had the Mosdale decision, that revenue argued primarily to the Mosedale, well, to adopt the Mosedale conforming construction. But as you saw from the submissions, first position was don't say anything about interest because it's not within your jurisdiction. And actually the FTT and Redevco agreed with that. It sets out the conforming construction at the end of its decision. It says nothing about interest. So we were saying adopt the Mosedale conforming interpretation.
But now you're saying the opposite.
Well, we said say nothing about interest.
I know, but you were saying adopt what Judge
Well,
Mosedale.
without the bit on interest, essentially, was our submission. And we got that. We succeeded because if we go to the FTT decision in Redevco, in the core bundle, tab 8. I think it's right at the end. Judge Brooks sets out at paragraph 62 the conforming construction he is implementing. It doesn't include the wording that Judge Mosedale included, saying anything about interest. Interest is left at large in Redevco. And I can take you there now. Well, actually, I think I can. This is basically what I'm going to do. Let's deal with it. What happened before the Upper Tribunal? It's in the supplemental bundle. At page 197. It's the transcript. What actually happened before the Upper Tribunal? So you've been taken to the Upper Tribunal's pleaded position for the Upper Tribunal. There was an appeal in Panayi saying you shouldn't have said anything about interest because it's not within your jurisdiction, definitely not in the disposition section. But also, you adopted the wrong conforming construction. That was the pleaded appeal point. In submissions, the revenue ran primary case and alternative case. The primary case being run was that Judge Mosedale's decision was correct. The alternative position being run was that actually interest could run from the original date. And what you see, it was going to be run anyway, but it actually comes from an interaction with an intervention from Judge Alexander. It starts at, sorry, maybe I've taken you to the wrong page. Sorry, it starts at page 191. It starts internal page 11. I said I would deal with the points on interest. And then it's stated, this is Mr. Brennan's submissions, and I, for Redevco, adopted the submissions, but I also say my own point. There's no issue being in relation to interest, because of course justice consistently held the national rules on deferral allow interests. And the primary position being put is, well, strictly speaking, if you need to read the interest provision subject to conforming construction, if you change the date in 59B, then interest will run from that date. Then Judge Alexander, on internal page 13, intervenes. He says, well, maybe, but what if we just put the deferral provision in a different subsection? Wouldn't that mean that interest runs from the ordinary date? That's another way of doing this. And that's what, it's in the course of that exchange, Mr. Bremner moves on to the alternative position. At internal page 16, we want to do as little violence as possible and adjust as little as possible, so leaving 31st January due date in place for the purpose of interest. That does not mean that this is to be a possible interpretation. It's just a function of the legal analysis. So that's the submission being put in the alternative. And then there's reference to 28 to 281. and then at the top of internal page 70, I have no difficulty at all in saying that when it comes to the Tribunal's legal analysis, that's when the Tribunal were to conclude it best fits the UK provisions. And then it's also stated below in line 16, it's all driven by the legal analysis of what EU law requires and what fits with the UK legislation. So the submission was clearly put before the Upper Tribunal. There are two ways you could, if you were thinking about interest, there are two ways you could deal with the interest. One is stick with what Judge Mosedale said. The other is, if you want to actually do what we say is the proper analysis, which is what the Upper Tribunal actually did, apply the principles. We say that the correct answer is actually interest continues to run. And then my submissions for Redevco. On page 197, I had expressly, earlier in the extracts, you've got adopted the submissions that Mr. Bremner made for Panayi, mutatis mutandis, but then I did also say expressly interest. Interest will follow from your decision as what the appropriate conforming instruction is. We've seen section 8.7a, will generally run from the due date and payable. Probably the analysis that is closest to CJ's jurisprudence is that interest does indeed run from the original section 59D date. And I go on to say, internal page 120, that it's closest to the grain of the legislation. So, HMRC, having had the Mosedale decision, which on the interest point you might say was against them, appealed against that, so it was pleaded properly in the Panayi appeal, because the Panayi actually had a decision on interest. In Redevco there was nothing said about interest. Mr. Bremner then addresses that in the context of an issue that was before the Upper Tribunal. In the course of my submission saying, does interest stop you doing a conforming interpretation? The answer is no, and this is what we say the answer is. So we did squarely run this before the Upper Tribunal.
So the sort of minimalist approach might be to say the FTT had no jurisdiction to deal with interest, and it erred in law in doing so. Full stop, end of story.
And that is, to the extent binding, that is all the Upper Tribunal actually says.
Yeah.
That is an answer before you. And that effectively was what the appeal to the Upper Tribunal in Panayi was, and the Revenue got the answer they wanted on that.
All right.
That would save me time later, because that was going to be a response to round 4 of the Redevco grounds. We are now going to do the slightly speedy version of a response to the main points raised by the two appellants as to why conforming interpretation cannot be assumed. And effectively, they've got 3 arguments, 3 main points run. The first one is the alleged prohibition on a statutory scheme. The second is the impermissible choices, and the third is certainty and retrospectivity. And the first point I'll deal with shortly, the others I'll do by reference to case law. And for reference to the cases, for policy choices are going to be Lambert, Routier, Ries, Anderson, Maybe Guyden, Ofgem, Ampleweird, and Gallagher. And for legal certainty, we're going to look at PPCN, Locke, and Fleming. But in relation to scheme, the alleged prohibition on the reading in the scheme, briefly, our answer is, as I mentioned yesterday, that there is not an ill-defined extra limitation to the application of a conforming construction, because as we will see as we work through the case law, when a court refers to a scheme, it is actually referring to one of the recognised limitations, i.e. grain, fundamental feature, or impermissible nature choices. Calling the legislation a scheme adds nothing. If the point is being made as well, it's about the significance of the amendments. Well, 2 points there. Firstly, the error is really that they're saying that what the Upper Tribunal did is read in 3ZA and 3ZB, because that's not what it did. It read in the Upper Tribunal formulated a concise but effective set of wording that rendered the legislation compliant. And that is certainly not a detailed scheme. It's just adding one relatively short exception in a regime providing for timings of payment. It's certainly no more complicated than the exception introduced in Vodafone, and far less complicated than the dual credits introduced in Prudential, developed an FII, which created a novel form of credit. So this is not a detailed scheme, whatever that means. It's a relatively short exception being introduced into a regime already dealing with payments. And the wording gap to be filled does not add anything. In Vodafone, Prudential and FII, there was also a gap to be filled. The legislature to make it more compliant. The courts, if you want to put it in that wording, filled that gap. And under this heading, I would just briefly like to mention Lambert. I'm not going to take you to it. Our point on Lambert is, Lambert talks about there being a barrier between what's permissible, which it refers to as interpretation, and what's impermissible, which is called amendment. But Lambert in itself does not tell us anything about what the dividing line is. And those are, of course, merely labels. Interpretation versus amendment. It means the right side and the wrong side applying the principles. So let's get on to impermissible choices. You've already heard my 3 responses on why there are no impermissible choices in this case. So now I'd like to turn to some of the case law. For your note, you may find it helpful to look at IDT, which is tab 43, page 890, which is a summary of what types of choices might be impermissible. Essentially, it talks about protection of third parties, creditors, and consumers. That's a sort of general point. Keep those in mind when we now look at some of the cases. Re S, which is tab 39, if I may, I will give the summary and give you the paragraph references, and then potentially take you to the paragraph at the end. So Re-S was about care orders. I hope that's right. Am I giving that? Yes, tab 39 starts at 692. Re-S is about care orders. Both the Court of Appeal and the House of Lords decided the legislation was incompatible with human rights, Articles 6 and 8. The Court of Appeal applied a conforming construction, the House of Lords disagreed. And the headline is it reached that conclusion because the conforming construction breached a fundamental feature of the legislation, which the House of Lords identifies in terms in the course of its decision. And if I may, the paragraph references. Paragraph 23 on page 710, we'll see this mentioned throughout the document. This is Lord Nichols's judgment. Starts by saying a cardinal principle is that when the court makes a care order, it becomes the duty of the local authority designated by to receive the child in its care while the order remains in force. Page 710, paragraph 23. The point we will see repeated is that Parliament has provided that whilst a care order is in place, the responsibility is the responsibility of the local authority. The courts have no supervisory jurisdiction. You can't appeal to a court or seek directions. And that's paragraph 25. There's a reference to exceptions. These exceptions do not detract significantly from basic principles of the Act, delineated the bounds of responsibility with complete clarity. Where a care order is made, the responsibility for the Carl's chair is with the authority rather than the court. The court retains no supervisory jurisdiction. Paragraph 27, this cardinal principle of the Children's Act represented a change in the law, so it was a conscious choice. Paragraph 28, I've described a cardinal principle. There's also, for your reference 29, talking about the resources of local authorities, because this is a case where you're not just talking about the child and the parents, you've also got to think about the local authorities. Now, what the Court of Appeal had done, for your reference, it's paragraph 17, is introduce something quite radical, which has introduced, given the court a jurisdiction, and then it had actually gone further and introduced the system of starred milestones. But given what we've already seen about cardinal feature, it's not going to be very surprising that the House of Lords says, no, you can't do that. It's paragraph 40 on page 74. It starts, it's the sentence beginning between F and G. For present purposes, it is sufficient to say that a meaning that departs substantially from a fundamental feature is likely to cross the boundary. That's the principle, and then 42 is the application. I return to the Children's Act. I've already noted it's a cardinal principle of the Act that courts are not empowered to intervene in the way local authorities discharge their parental responsibilities. Parliament entrusted local authorities, not the courts, with that responsibility. And then Lord Nichols summarises what the new system will entail. And 43, the sentence says, it's talking about the boundary, and it says, on the contrary, the starring system is inconsistent with an important respect of the scheme of the Children's Act. And then he also goes on to say it would also have far-reaching practical ramifications for local authorities. And that picks up on what we saw earlier about funding. And it is on that basis we get to 44. These are matters for decisions by Parliament, not courts. It is impossible for a court to attempt to evaluate these ramifications or assess what the views of Parliament would be. And there's a reference to occasion about a sensitive and controversial field, and that is why it's said, and that is what leads to, in my view, in the present case, the Court of Appeal exceeded the bounds of its judicial jurisdiction under Section 3 in introducing this new scheme. That is because of the reasons already given. We distinguish RIA. So RIA was all about, there was a cardinal feature, there were also all these ramifications in the sense of third party, because you've got the child, the parent, and you've also got the authorities with their funding difficulties that have been, funding restrictions have been noted. None of those features arise in this case. There is no cardinal feature that's being breached. In fact, we say there is a deferral mechanism ready for uncrystallised gains. We know what EU law requires, nor is this a sensitive area in the same category as child laws. Yes. Anderson, tab 40. Anderson is actually in a very similar category, because it was about the court giving itself a right to intervene, where Parliament had specifically allocated the role to another person. And we see that in particular at page 793, Lord Hutton. So the legislation, so the answer is in 79 to 81. The legislation introduced was Section 29 of the Criminal Sentences Act. That legislation made it clear that the power and release in that particular case, when those particular circumstances, was to lie with the Home Secretary and no one else. And that is what Lord Hutton observes at the end of paragraph 80. Parliament has given him, the Home Secretary, the power to decide that the prisoner should not be released. And the interpretation providing for an alternative scheme whereby the power was taken from the Home Secretary and given to the judiciary plainly went against the grain of the legislation. It was inconsistent with the cardinal feature of that scheme. And that, for reference, is what was meant in Guidon. Tab 41. Guidon then discusses this, and a lot of emphasis is put on the word substituted scheme. Page 811 is Lord Nichols, same judge as in Ries,
Sorry, just going back to Anderson, that was Lord Hutton. Lord Bingham gave another. The other judges agree with Lord Bingham and Lord Hutton. I was just wondering what Lord Bingham said. Oh, and Lord Stenge.
May I take that away over the shorter journeys, just in the interest of time? If I may, just in the interest of time, I'll come back to some paragraph references addressing that.
Lord Bingham said at paragraph 30, to read section 29 precluding participation by the Home Secretary, which you say would not be judicial interpretation but judicial vandalism. So that seems to be
Stronger.
stronger.
Yes, it's one of these cases. It's not quite Fleming, but it's one of the cases where Lord Nichols certainly agrees, and everyone gives their own view, but in a slightly different way. We do say the theme, I will just double check that over the shorter journals, is that it's about cardinal feature, and that's how the case has been explained in later case law. So we're about to look at guidance. Tab 41 at 811. Paragraphs 33 and 34. Lord Nichols introduces those cases, and he says of the Anderson, Section 29 could not be read in a conventional blind way without giving the section an inconsistent with an important feature expressed clearly in the legislation. And you see the same for your reference. It's paragraphs 111 to 114 of Lord Rogers' speech. And we say Lord Stenge, at paragraph 49, is not saying anything different. And he refers to R. Anderson. The House found that it was not possible and made a declaration it could not provide a substitute scheme. So the scheme we've already seen gave the power to determine the sentencing to the Home Secretary. You couldn't have a substitute scheme, if that's the word you want to use, giving the power to the judiciary instead. That is how Ries and Anderson were decided. Primarily on cardinal feature, and we've also seen reference in Ries to ramification that the court could not evaluate. May I move us on to Ofgem and Hytel, which is in the authorities bundle. Tab 63. I do appreciate the long end of the court together. Decision is always dangerous to explain to a judge how they decide. In summary, the case is about whistleblower claims made in the Employment Tribunal, and the employee applied to Ofgem to make certain disclosures. Ofgem said they were blocked by this prohibition in Section 105. Section 105, for your note, is set out in paragraph 36 of the decision, and paragraph 37 were various exemptions that were applied, and it was considered that was incompatible with Article 6. Paragraph 43, we have the discussion, it's on page 1859, we have the discussion of res, and the final two lines, the procedure, as the court provision was inconsistent with a fundamental feature of the primary legislation. And then at 47, the reference to the far-reaching practical ramifications. We say that is the correct characterisation of Lord Nichols' decision. And then paragraphs 47, 48 and 49 are on and 51, and 50 and 51 are on Anderson. And those paragraphs confirm the reasons why the courts were unable to provide conforming construction. There is a reference to Lord Bingham. Yes, and that's the reference to judicial vandalism. And there's a reference to Lord Stain that the interpolation would be inconsistent with the plain legislative intent to entrust the decision to the Home Secretary. So those are the two decisions, the two judgments cited there. We say once again that is the correct characterisation of Anderson. And then we turn to the decision in Ofgem. And we're heading on page 1867. Is it possible to read 105 in a way that's compatible with conventional rights? The start of the analysis is the statutory scheme, described at 78 as a carefully crafted scheme of exceptions from the prohibition. The grain or thrust or pith of this provision is the Parliament has carefully considered in precisely what circumstances and legal context the wide prohibition should not apply. And then there's a reference to the relevant provisions, because each exception had ramifications, and I understand that legislation was printed out, i.e. the legislation which may have affected, and it filled 4 lever arch files. So they show Parliament has given careful thought to the relationship between the prohibition and a range of other statutory regimes in which disclosure might be necessary or desirable. And then there's a reference to Parliament's intention being that the Secretary of State would be the gatekeeper. Now, 81 inferences. It's not that Parliament overlooked the enactment, it's that it intended the prohibition would apply, that it's considered a cardinal feature that actually Parliament has been very precise. Paragraph 85 onwards, the court lists 4 ways in which the proposed interpretation would be implicitly contradicted by the thrust of the legislation. I won't go through them, but suffice to say none of them apply in this case. One of them is actually the reference that it was a human rights case and Parliament remains entitled to legislate contrary to the Human Rights Act. And in paragraph 91, the court addresses the second factor. This is an area where the court is not equipped to understand the effect of a piecemeal amendment of one provision to an intricate system, just as a layperson would think twice about trying to fix one cold radiator in the attic of a huge building by opening up the boiler in a distant basement and loosening a random nut. And then at 92, this is a policy area if Parliament or the Secretary of State in themselves of power is in a much better position to see the big picture. It's talking essentially about ramifications. Ramifications which the court cannot foresee or evaluate. And because there were indications that there had been a deliberate choice about whether or not Section 105 would include what exceptions 105 would apply to, which civil proceedings. And neither of those factors apply in our case. The statutory regime is straightforward, the conforming interpretation is straightforward. There are no unforeseen knock-on effects. The only knock-on effects are the ones we've been discussing. that is often. Routier is tab 65. I will take this one. Summary level. Paragraph, the reason it's a paragraph 50 onwards at 1999, and I feel the court already has a feel for what I'm going to do this. But in summary, there was legislation. So let's start with this point. We say that the appellant is trying to say that Routier supports that reading in words, or that there's some form of restriction on conforming interpretation. We say that as a misreading of Routier, because as held by the FTTs and the Upper Tribunal in our cases, Routier does not provide any guidance on conforming interpretation.
Sorry, Routier does not?
Does not provide any guidance on conforming interpretation, because in summary, in Routier, there was no restriction at all. The only possible restriction was a judge-made restriction, not the legislation itself, and therefore there was no need to apply a conforming interpretation. And that's set out at paragraph 50 onwards, is that the only problem, so the legislation itself was fine, there was no breach on the literal wording. The problem was that traditionally they'd been read in a gloss, a judicial gloss, like Dreyfus, and it was the Dreyfus gloss that caused the restriction by saying that it had to be a UK charity under UK law. And the Court of Appeal has said, okay, well what we'll do is we'll basically apply a conforming interpretation to the Dreyfus gloss and extend it to overseas charities. Supreme Court says no, not because the conforming interpretation would sort of somehow be restricted in an appropriate case if that's what the legislation said, but just because the legislation didn't say that. Let's say paragraph 50, on its face the legislation does not discriminate, section 23. Paragraph 51, the only relevant restriction is the Dreyfus gloss. Paragraph 52, simple answer, don't apply the Dreyfus gloss in cases where EU law rights are engaged. And that is what is meant. 53. That is the conclusion which the Court of Appeal should have reached. Once it's decided the Dreyfus gloss, if incorporated, imposed a restriction, having reached that decision, the Court could not apply that entirely judge-made restriction. That's a reference to the Dreyfus gloss. It's not a reference to the conforming construction. And therefore had to apply section 23, essentially on its plain language. And then it would have reached a result that was already compliant. So basically just read the legislation. And you see that 54 as well, a couple of lines down. The fact was there was no such restriction in existence. So the court is saying, Supreme Court is saying, no, we don't have to do a conforming construction. And of course, if the legislation is conforming, you don't have to do a conforming construction. Actually, the answer is you can't do because it's only where the legislation breaches EU law. Same approach for FII Supreme Court 2012. Which is at tab 50. Bringing up Lord Sumption's judgment, I was asked yesterday about whether Lord Sumption is in the majority, and actually maybe we should deal with that first. The answer is, on this particular paragraph, it is difficult, because if you turn this to 1170, there is a summary by Lord Hope of who is agreeing with whom. And for most issues, there was agreement. There were some issues where Lord Walker and Lord Sumption disagreed. Now, the bit that I struggled with is that in the list of paragraphs which are agreed, we were looking at 176. And it's identified, the 4 lines down, that 171 to 174 are part of the agreement, and then 4 lines below that, 177 to 185, but 176 is missed out. And that was actually just setting out a principle, but I will say this, which is that it is picked up by Lady Justice Falk in PPCN, we're going to get to, which is paragraph 42 of that judgment, that has been effectively endorsed, we say. In addition, the further complication is on the bit they don't disagree with. They do agree that a reference should be made, which in a sense is the order of the courts. But the point I'm responding to is page 1238.
1238.
1238, yes, which is it was paragraph 205 as relied upon. So it's 204 and 205. Summary, this is very similar to Routier. The problem is not with the legislation, the problem is the judicial gloss. And it's all about section 33, which for your note you can find not in this judgment, but at tab 48, page 1091. It's not even actually set out in this judgment. And that is a positive ability to make a statutory claim for overpaid tax. The problem for EU law purposes was the courts had read that as not just a positive right, but an exclusive right. It implicitly excluded common law rights. And that's stated in 204 between E and F. This does not, of course, matter if it is an additional remedy. There is certainly nothing in the provision which expressly excludes the availability of other causes of action. So the provision itself did not exclude anything. There was an interpretation floating around which said, well, maybe it is exclusionary, which means you can't have a common law remedy. Yes, there is certainly nothing in the provision which excludes a common law. If that's its effect, it must be by implication. In the ordinary way, such an exclusion might be implied on the ground that where Parliament confers a restricted right, that displaces another common law right. However, it's axiomatic. The courts cannot imply an exclusion without being consistent with an overriding EU law that an unrestricted right must be available. Section 33, therefore, cannot be an exclusive right to recover tax charged by when it's contrary to EU law. Whether it is an exclusive right in other circumstances, i.e. for non-EU law situations, is not a point we need to consider. So, court's saying, regardless of how we might otherwise interpret section 33, when we're looking at EU law, we're just going to apply it on its terms, that it's a positive right, but you've still got your common law right alongside it. And the mistake at 205 is the Court of Appeal held that section 33 did imply to exclude a right of action, so they applied the gloss. Then they dealt with that inconsistency by reinterpreting the section. So they had a gloss and they effectively did a conforming interpretation with the gloss. I very much doubt whether such radical, so having read it in a restricted way, they then tried to broaden it again. I very much doubt whether such radical surgery can be justified. Its effect would fundamentally alter the scheme of provision. It seems eccentric to apply an ambit for section 33, which is inconsistent with EU law, and then torture it. Simple answer, just don't read the restriction. That's why it is analogous to Dreyfus. But those are cases which largely might be said to look at sort of statutory scheme impermissible choices, although we say they don't help the other side's case. We're now moving on to legal certainty, which is the other main point. I think I can get one case break. I wanted to deal with the phrase contra legem, which is brought in. So legal certainty covers the appellant's case contra legem, certainty, retrospectivity. Tab 58 is British gas and law. So the EU law the headline is the EU law concept of contra legem has been incorporated into the domestic principles in a very particular way. On page 1667. paragraph. If we could go back, please, to 1665. Apologies, back to 1655, just to see the submissions being made about contra legem. So there are submissions being made there, 63, 64, and then 65. There's a reference to impacts, and then there's also the reference to dance industry, either saying cases relied on before you in support of the contra legem principle. So this is how the court is going to deal with those submissions. And then at 1667, this is the decision of Sir Colin Rymer. But under the heading, that was submissions, we're now under discussion and conclusion that starts at paragraph 96. Paragraph 101 to 104. The court addresses the contra legem principle, including by reference to the opinion of the AG in Dansk. And at 102, Sir Colin Rymer says, well, this seems a bit odd if you read it literally. It doesn't seem very consistent with conforming construction. I do not see how the House of Lords could have decided Pickstone as it did if it applied the contra legem principle as so explained, i.e. so submitted before that court, and similar to the one where it's submitted before you. And what's said at 103 at the end, after the downscript, when faced with the question of whether conforming interpretation be adopted, the courts of the UK do not confine themselves to the consideration of the literal meaning. They approach the task by reference to the broader consideration of whether conforming interpretation would be in line with the grain or the underlying thrusts. That's the approach I think that should attract nothing but commendation from the CJU. I do what you can. I do not therefore derive a system of Gavin's contra legem submissions. In my view, the critical question comes down to whether conforming interpretation in which he contends is within the grain or underlying thrust of the legislation. I consider it ought to follow the interpretation favoured by the tribunals below. So the courts have incorporated the EU concept of contra legem, not literally, but as part of the principle that conforming construction should not go against the grain.
On that, just for you to think about over lunch, I think that same passage was referred to by Lord Justice Lewison in Appellant.
Yes.
The same bit from the Dansk case.
And yes, and I'm going to be submitting to you Lord Justice Lewison. I mean, there is a reading of his judgment. It makes it sound like he's cutting across everything that's ever been said about. We say when he's talking about the wording, he has very much in mind. We say a similar principle. When you're cutting across the wording, you don't mean literally the wording. We mean against the grain. Otherwise, that would be a very radical departure from the principles of conforming construction.
And I don't know, I mean, it might be worth just checking whether this decision was referred to in the Ample Award case. I'm not asking you to do that now, but it would be...
We may be able to do that over lunch. You should have
to know
some cases referred to. Okay, so after lunch, ideally, we have post-prudential closure notices and one or two more other cases to go through. And then I'd like to run through the Upper Tribunal's reasoning, which will largely be saying it's right. We've already dealt with infringed, so I think we're just left with one ground we need to do with the skeleton, and I'll be handing back to Mr. Fell.
But you have an hour left. Thank you. 2 o'clock.
But whereas